students here today, and the student organisers, Charlotte and my colleague, Dr. Gemma Turton, who are both going to judge the moot, or pretend to be judges, with me today. But particularly thanks to the students giving up their Saturday to do this. You might ask, well, what is a moot? As you can see, we are a court of 3 judges here today, so we're actually hearing an appeal from a single judge's decision. We're not hearing the case from the start. The judge has already heard the case, heard the witnesses, made decisions of fact, and then made a decision of law as to whether the claimant is successful or not. A moot is a mock appeal proceeding where the parties are arguing that the judge at first instance got it wrong, either made findings of fact that could not be based on the evidence or had got the law wrong in some way. So a moot essentially is about what we often call a moot question. A moot question is one to which there is no easy answer. If there was an easy answer to many legal questions, there would be no litigation, there would be no appeals, there would be no differences of opinion. And anybody reading the papers at the moment knows how there can be very critical differences of opinion between judges. And often the final story will be whether something goes to the High Court of Australia. It can only do that by leave of the High Court, but that's it. That's the end of litigation. That's the last road of appeal. And we think mooting skills are very valuable, not just for those students who will go on to become barristers and who will spend much of their professional life appearing in court and arguing cases for clients, but also for any lawyer or for anyone who wants to learn some legal skills, because essentially mooting is about advocacy. It's about putting an argument for someone else. And one of the things that lawyers do, or lawyers learn to do, is put arguments for other people. That's really one of their most important functions. And one of the things that we try and help students develop is their ability to get a whole lot of information, put it into some sort of logical order, and then think about the arguments for and against a particular situation or a particular legal answer. They have to not only look at the facts from their client's point of view, but they have to put themselves in the position of the other side and see what arguments could be put against them. And that's one of the skills that mooting really helps students develop. Of course, it also helps them get to know the law really well. If you have to stand up and argue something in front of a fairly critical judge and your peers, you have to really delve into the legal issues, read the cases, read what their textbooks say, put all the arguments together. So it's a great way of actually learning your subject matter that you need anyway for your exams and your assessments and essays. It's a great way of doing it better. And then I would imagine that all the students would attest of the camaraderie and the teamship and the collegiality and the fun that you might have in mooting. Charlotte here went to Washington last year as part of the Jessup Moot team after being the national champions, and I'm sure you would have had a pretty good time in Washington as part of that international competition. So as you know, Sydney University has had great success in the Jessup Moot. Sydney Law School students have won it 5 times, the Jessup International Law Moot, more than any other law school. But we also send students to Geneva for the Viz Moot. There's a maritime law moot, and then there are numerous intervarsity moots. Now I have to say that the faculty, or the law school, couldn't do this without the enthusiasm and support of the students who give up an enormous amount of their own time to actually run this program. So it's very much a sort of student-run program, and the law school helps when we can. Academics, of course, will come and do practice moots and practice judges, but a lot of it is the student-run, which is, I suppose, part of the fun. In addition to mooting, the Student Law Society also runs competitions in client interviewing, witness examination and negotiation. So it's not just about learning the law in detail, it's also about those other skills which are so important when you go out into the world after a law degree. So with that introduction, let us start with our appeal today. As you'll see, we're using, for the moot problem, a problem that was used in the Torts moot competition. Torts is a subject that I teach in first year and that Dr. Turton also teaches. Torts is a subject about wrongs that people do to each other, where one person is suing another for compensation, usually. It's often contrasted with a criminal case where the state is prosecuting someone for a crime. If you say that someone's committed a tort, you're saying that they've committed a wrong against somebody else and that someone else can sue them for compensation. So this is a torts moot, and I think I will now call on the parties on the advocates to announce their appearances.
May it please the court. My name is Manousaridis, Manousaridis, initial T, and I appear with my learned junior Touw, Touw, initial A, on behalf of the appellant in this matter. I will speak for 9 minutes, and my learned junior will speak for a further 11 minutes. May it please the court.
Thank you, Mr. Manousaridis.
May it please the court. My name is Lee, L-I, initial R. I appear with my learned junior, Naylor, N-A-Y-L-O-R, initial S, on behalf of the respondent, Safe State Security. I will speak for 10 minutes, and my learned junior will speak for a further 10 minutes. May it please the court.
Thank you, Ms. Lee. Yes, Mr. Manousaridis.
May it please the court. Ms. Cerise Bannister, a security guard employed by the respondent, attended a property at Somerville as part of her duties on the night of the 20th to the 21st of May 2017. In the early hours of the 21st of May, Ms. Bannister witnessed the sudden death of Mr. Stark. She developed post-traumatic stress disorder and as a result brings an action in negligence against the respondent. We appeal the decision of Justice Bolton on 2 grounds: in respect of damage, found at paragraph 96E of the judgment, and contributory negligence, found at paragraph 96F of the judgment. And by way of cross-appeal, our learned friends challenge Justice Bolton's finding at paragraph 96D of the judgment that Safe State breached its duty of care owed to Ms. Bannister. I will make one submission on the cross-appeal, namely that Justice Bolton did not err in ruling that Safe State breached its duty of care owed to Ms. Bannister, and my learned junior will make submissions on the appeal. We note briefly that our learned friends accept our submissions in regards to the existence of a duty of care by Safe State to Ms. Bannister to provide her with a safe system of work, and also accept our characterization of risk as a precursor for the analysis of whether this duty has been breached. We will therefore make submissions in relation to whether that duty has been breached. In order for this court to make a finding on whether a duty of care has been breached, we must consider the 3-part test found in section 9, subsection 1 of the Queensland Civil Liability Act of 2003.
And did the trial judge consider this legislation?
No, he did not, Your Honour. However, the court can still make a finding in relation to breach if he did not, as long as the court finds that it wasn't material to the outcome. So His Honour made a finding on whether the risk was reasonably foreseeable. However, pursuant to the Uniform Civil Procedure Rules of Queensland, Rule 766(1)A, this court may consider the issue for itself. The 3-part test in section 9, subsection 1 of the Civil Liability Act requires that the risk was foreseeable, which His Honour has already made findings on, that the risk was not insignificant, and that in the circumstances, a reasonable person in the position of Safe State would have taken the precautions. Our learned friends contest His Honour's findings that the risk was not foreseeable. However, as this is a finding of fact, in order for this court to overturn that finding, this court must be satisfied that the risk was glaringly improbable and contrary to compelling inferences, as held by the 2003 High Court decision of Fox and Percy. Your Honours, we submit that this threshold has not been reached by our learned friends. There are a number of reasons that we can point to on the judgment that suggest that the risk was foreseeable. At paragraph 20 of the judgment, for example, it was foreseeable that Ms. Bannister would have suffered post-traumatic stress disorder following the incident, as she spoke with a number of employees who noted that she was visibly shaken and suggested that she go home following the incident, as you would expect after witnessing the violent death of a man. Moreover, at paragraph 21 of the judgment, Ms. Bannister had a meeting with her supervisor the following evening when she attended work as usual. She described the events to her supervisor, however, and the supervisor told her that this sort of thing was just part of the job and insisted that she go out on her rostered patrols, insinuating that she was reluctant to go out on the patrols that she was rostered to go out on. Moreover, and perhaps most compellingly, at paragraph 22 of the judgment, Ms. Bannister for the following weeks avoided call-outs in the same general vicinity as the brawl which she witnessed the death of Mr. Stark at. Now, we submit that because of these factors, and because of the unwillingness to perform a crucial part of her job, that is attending an area which she is required to do as part of her duties as a security guard, that it was reasonably foreseeable for Ms. Bannister to develop post-traumatic stress disorder following witnessing the death of Mr. Brian Stark.
What about prior to the incident? So I understand that there's some breaches that you're alleging that go to whether they should have referred her to debriefing once the incident had occurred. But what about the training beforehand? Was it also foreseeable that that would be necessary?
Yes, Your Honour. That is part of the precautions we are alleging that the respondent should have taken. And that goes to the fact that as security guards, Safe State should have been reasonably foreseeable to Safe State that its security guards may have developed post-traumatic stress disorder based off the threatening work that they encountered. And we can see that this was apparent to Safe State. Paragraphs 9 to 11 of the judgment, it goes into, His Honour goes into the findings on the nature of the work that Safe State security employees were meant to undertake. Ms. Bannister, at paragraph 10 of the judgment, regularly attended call-outs, and at paragraph 11 of the judgment, His Honour makes a finding that she had been involved in a number of threatening situations, and on 3 particular occasions she was threatened by intoxicated individuals. So we submit that this goes to the fact that it was reasonably foreseeable and Safe State should have taken the precautions that Your Honour pointed to.
Mr. Manousaridis, can we take any weight from the fact that in other cases courts have found that certain risks are reasonably foreseeable?
Yes, Your Honour, and one particular line of cases that the High Court and this Court on a number of occasions have dealt with is that of first responders, both police officers, for example, and paramedics. The High Court case of New South Wales and Fahey deals with this very question of whether the risk of suffering a psychiatric illness was reasonably foreseeable.
But isn't it part of the job for those sorts of occupations?
Yes, Your Honour, it is part of that job. However, that doesn't necessarily mean that it can't be reasonable foreseeable for the question of whether a breach has occurred. We also note that our learned friends contest that the risk was not insignificant, which is the second part of the three-part test found at section 9, subsection 1b of the Civil Liability Act.
What's the difference between not insignificant and reasonably foreseeable?
It is a subtle one, Your Honour, and this court dealt with that question in the case of Miandara Aerial Spraying and GEJ and MA Geldard Proprietary Limited. His Honour, the court stated that the difference is a subtle one, and the increase in the necessary degree of probability may not be quantifiable in a number of cases. However, the court and other courts have held that in order for a risk to be not insignificant, the risk must be probable, more probable than a risk that was not reasonably
Are we
foreseeable.
talking about precise probabilities here? Do we need statistical evidence about risks occurring or anything like that for us to make up our mind?
Not necessarily, Your Honour, and the New South Wales Court of Appeal in the case of South Sydney Junior Rugby League Club and Brazos stated that other factors including obviousness and the seriousness of the consequences, which we take to mean general risks, are sufficient for this court to make a finding. And that goes to the facts which I previously referred the court to in relation to the fact that Ms. Bannister is a security guard who is tasked with guarding property, and on a number of occasions during the 2.5 years she has worked at Safe State has faced threatening situations. And we submit those facts go to the fact that the risk in question is not insignificant.
Can I ask, is it the risk of encountering threatening situations that you're arguing is not insignificant, or the risk of subsequently developing post-traumatic stress disorder?
The risk of subsequently developing post-traumatic stress disorder or other psychiatric illnesses, Your Honour. Finally, pursuant to Section 9, subsection 1c, which requires the court to consider the factors listed in Section 9, subsection 2 of the Civil Liability Act, we submit that Safe State should have taken a number of precautions, and that a reasonable person in their position would have, to prevent Ms. Bannister from suffering psychiatric harm. That includes training Ms. Bannister to deal with threatening situations, training its employees to identify the signs and stresses of psychiatric illness, as well as adequately debrief Ms. Bannister. We note that pursuant to paragraph 25, pardon Your Honours, of the judgment, expert testimony was given by Dr. Marjorie Moot. Now, it states at paragraph 25, subsection 2 of that paragraph, that intervention in the form of timely counselling may have been useful in some circumstances, and at paragraph subsection 3 of that paragraph, that it was possible that had Ms. Bannister been adequately debriefed and referred immediately to counselling, that her symptoms may have been alleviated.
Time's running out.
Yes, Your Honour, I'll briefly conclude. And we submit that that goes to the likelihood of those precautions reducing the risk of harm that Ms. Bannister may have suffered. If Your Honours have no further questions, that concludes the submissions on the cross appeal. I now defer to my learned junior, who will continue the case of the appellant. May it please the court.
May it please the court, I will address the appeal, specifically the issues of causation of damage found at paragraph 96B of the judgment, and contributory negligence by Ms. Bannister at paragraph 96F. Turning now to my first submission, we submit that Justice Bolton erred in finding at paragraph 96E of the judgment that Ms. Bannister suffered no significant or valuable loss of chance, and hence no damage. The Civil Liability Act of Queensland acts to limit the scope of the common law action for negligence, and the relevant provision in this case is Section 11, in that Safe State must have caused Ms. Bannister harm. Contrary to the submissions of my learned friend at 2.1 of their written submissions, we submit that the definition of harm under the Civil Liability Act is expansive enough to encompass a loss of chance, if Your Honours find it is actionable. We base this submission on
What is that definition of harm?
that harm is harm of any kind, which includes personal injury, damage to property, and economic loss. But we submit that this is an inclusive definition and is not exhaustive. And we draw on the case of Malone Consulting in Ashcroft, a 2018 decision of the New South Wales Court of Appeal. The damage we are claiming for in this case is a loss of chance, which involves proof on the balance of probabilities that the appellant lost a chance of a better outcome. To be actionable, as correctly stated by the learned trial judge, this chance lost must be both valuable as a question of law and significant as a question of fact. The test for value is that the chance lost must have a real value independent of the final outcome, as stated by Justice Kiefel in Tibet and Get, a 2010 decision of the High Court of Australia at paragraph 124.
But didn't the High Court in that case find that in actions for medical negligence there was no independent value? So how can we find that there is independence in this case when it still relates to a medical outcome, which is her suffering PTSD?
We submit that the High Court in Tibet and Get did not close this issue, and we refer to paragraph 27 of the judgment, where Justice Gummer states that this decision does not preclude a claim for loss of chance in absolute terms. And further, Tibet and Get was a case of medical negligence, whereas this is a case where an employer failed to provide a safe system of work. There are different sources of the cause in this case. In cases of medical negligence, such as Tibet and Get, where a doctor failed to provide a CT scan to a 6-year-old girl after she had a seizure and she suffered brain damage, the doctor is involved directly in the treatment of the individual. While in contrast, An employer only provides access to services, and this is a chance that is separate and provides value independent of the employee's choice to take up those services. Furthermore, contrary to the submissions of my learned friend at 2.3 of their written submissions, we submit that there are important policy reasons supporting the fact that the chance has value in this case. As an employer, and Ms. Bannister's capacity as an employee, Safe State had a significant degree of control over the system of work in which she operated, and hence the chance to access those resources has value. This control was recognised in the 1986 High Court decision of Condis and State Transport Authority, where it states that an employee has no choice but to accept and rely on the employer's provision and judgment in relation to the system of work in which they operate. We can see from the facts that Safe State controls the safeguards which Ms. Bannister had access to when encountering situations which threatened her safety. For example,
Sorry to interrupt. Does that degree of control not prevent the chance from being independent? In the sense that when a doctor is treating a patient, they affect their chances of a cure, and an employer not only provides the opportunity for access to counselling services or similar, but they have a degree of control in what provision is made and encouraging their employees to take that up. So do they not similarly, because of that degree of control, influence the substance of the chance itself?
no, Your Honour. It is our submission that the chance to be referred to counselling is independent of the employee's own decision to take up that referral. It is the chance that needs to be provided, we submit.
How are we going to quantify that chance? If this court held that it was not bound by the High Court of Australia in Tabbert and Dead, we made a distinction between medical negligence cases to which that case applies and said, well, this case is different, so we're not bound. How would we go about quantifying the chance?
Your Honour, that would be an issue for the assessment of damages, but it is our submission that this court has ascribed value to non-financial losses in the past and could do so again.
Thank you.
Turning now to the issue of significance, the second requirement for a loss of chance to be actionable. The test for significance is that the chance must be substantial and not merely speculative, as stated by Justice Keeble at paragraph 124 to that. The crucial issue here, as recognised by my learned friend, is whether Justice Bolton's finding of fact was contrary to compelling inferences, and it is our submission that it is. We turn Your Honour's attention to Dr. Mormont's report at paragraph 25 of the judgment, where at subparagraph 3, it states that it's possible that if Ms. Bannister had been adequately debriefed and referred immediately to counselling, her symptoms might have been alleviated. There is a possible chance here, and we submit that this is more than speculative, particularly considering subparagraph 2, where it states that timely counselling does not necessarily lead to a reduction in symptoms and can be useful in some circumstances and for some people. We submit that this shows a more than negligible chance, and while it does say did not necessarily, it's our interpretation of these words that it means that alleviation of symptoms is not an inevitable result of counselling, but it is more than negligible and speculative. Hence, on the balance of probabilities, the chance of a better outcome was significant. Turning to my second submission on contributory negligence,
What's generally the effect of contributory negligence? If we find that Ms. Bannister was guilty of contributory negligence, what's the effect of that on any claim she might have?
the effect of that is to reduce the amount of damages she can claim by a certain percentage to be adjudged by this court.
And how do we go about that task?
That is a discretionary decision involving the apportionment of damages. So,
Thank you.
we submit that Justice Bolton failed to apply the relevant provisions of the Civil Liability Act, and because of this material error of law, the findings of fact his Honour made should be overturned. My learned senior has outlined the principles of breach in Section 9, which, as stated by Section 23 of the Civil Liability Act, we use to determine contributory negligence. The critical question is what a reasonable person in Ms. Bannister's position would have done, as stated in Section 9, subsection 1C of the Civil Liability Act. My learned friend, at 3.2 of his written submissions, has submitted that Ms. Bannister made 3 contributory negligent acts by exiting the car, failing to call for assistance, and remaining in a position of risk. I will address each of these acts in turn. In terms of exiting the car, we submit, contrary to those submissions of my learned friend, that the probability that harm would occur to Ms. Bannister at this point was low and not likely to be serious, particularly when we weigh this against the high burden to take precautions. At this point, as stated at paragraph 14 of the facts, the people were merely milling around in the street, and it was a group of teenagers with loud music. We submit that this is not sufficiently threatening to justify Ms. Bannister remaining in the car, as she was required as part of her employment duties to place a business card at the door of the property. Justice Crowe, in a 2019 decision of the Queensland Supreme Court, Hoots and Concrete Panels and Oars, stated that when we consider breach, we balance the burden to take precautions to avoid the risk of injury against the duty of an employee to their employer to perform their role and duties. As I have stated, at paragraph 13 and 15 of the facts, the property was on the list of properties that Ms. Bannister was required to attend, and she was required to leave her business card there to confirm her attendance. Her supervisor even later said that the experience that she had gone through was part of the job when he took an incident report from her to detail her recollection of the incident.
Thank you, Ms. Touw. If we could perhaps move on to that last point that you want to argue about, which is whether or not, even if Ms. Bannister was contributory negligent, should that defeat the claim?
Yes, Your Honour. Our alternative submission is that Justice Bolton erred in finding at paragraph 96F that Ms. Bannister's contributory negligence should defeat any claim to damages, howsoever framed. The test to overturn an apportionment of damages by a trial court is that it must be unreasonable and unjust, as stated in the 2014 decision of this court, Queensland and Kelly. We submit that an 100% apportionment, as was made in this case, is manifestly unreasonable and unjust. In the New South Wales Court of Appeal case of Zanna and Zanna in 2010, the court stated that an apportionment of above 90% is only made in a very rare case, and that the risk the defendant creates must be patently obvious.
Have you been able to find any case in your researches where there has been a 100% reduction for contributory negligence since this legislation was enacted in 2003?
A 100% reduction for contributory negligence, to our knowledge, has never been upheld on appeal, Your Honour, though it has been made in trial courts.
Thank you. So your opponents are asking us to be the first court to uphold such a finding.
Yes, Your Honour. I note my time has expired, so if Your Honours have no further questions, I defer to my written submissions for the remainder of my argument. Those are the submissions of the appellant. May it please the court.
Thank you, Ms. Touw. Yes, Ms. Lee.
May it please the court. Your Honours, we acknowledge the misfortune that has befallen Ms. Bannister and the seriousness of post-traumatic stress disorder. However, the facts are that prior to the incident at Somerville, Ms. Bannister had already worked for 2.5 years at Safe State as a full-time security guard. Indeed, she had already encountered a number of threatening situations in the course of her employment, and yet on no such occasion did she sustain injury to her body or her mind. During the brawl that night, she chose not to call for assistance, despite her knowledge of the call-out system, and despite the fact that Safe State had equipped her with a two-way radio. After the incident, she continued to report for work and continued to perform her duties to an adequate standard. She now brings a claim against Safe State. In relation to this claim, I will address the cross-appeal on the issue of breach. My learned junior will address the appeal on the issues of causation, contributory negligence, and apportionment. Turning now to our first submission. We contend, by way of cross-appeal, that Justice Bolton erred at paragraph 96D of the judgment in finding that Safe State breached its duty of care to Ms. Bannister. This finding involved an error in law because Justice Bolton failed to consider the 3 elements set out in Section 9 of the Civil Liability Act as outlined by our learned friends. And all of these elements have to be satisfied in order to make a finding of breach.
Is it necessary for the judge to specifically refer to the legislation, or is it enough if the judge refers to the factors set out in the legislation?
The latter, Your Honour. However, it's our contention that in Justice Bolton, in failing to refer to 2 of the 3 elements, this was material to the outcome and the judgment that was reached by Justice Bolton. I now turn to the first element of breach. In light of our learned friends' submissions, we accept that the risk was foreseeable pursuant to Section 9(1)A of the Civil Liability Act. However, we contend that the second element under Section 9(1)B, that the risk is not insignificant, is not satisfied in this case. Your Honours, the concept of not insignificant is distinct from that of reasonable foreseeability. Whereas foreseeability is the common law test, which refers to whether the risk is not far-fetched or fanciful.
Which risk are we talking about here, as Dr. Turton asked the other counsel? Is it the risk of an event like this happening, or is it the risk of Ms. Bannister sustaining psychiatric injury?
It is the latter, Your Honour. It's the risk of Ms. Bannister sustaining psychiatric injury as a result of encountering a threatening situation in the course of her employment.
Are you arguing that it's not a not insignificant risk that she would encounter a traumatic situation, a violent situation in her work?
Yes, Your Honour. It's our submission that the risk was insignificant,
I see.
which means that it doesn't satisfy Section 9(1)B of the Civil Liability Act. And the meaning of not insignificant was explained by this court, the Queensland Court of Appeal, in the 2013 decision of Meandra Ariel Sprain, where Justice Fraser stated that there are 2 main variables that inform whether a risk is insignificant. The first of those is the probability of the risk occurring, and the second is the seriousness of the consequences should that risk actually occur.
Do you accept that it would be serious if it did occur, that she might suffer post-traumatic stress disorder?
Yes, Your Honour. We accept that the consequences of post-traumatic stress disorder are indeed serious. However, we contend that the probability of the risk actually occurring was very low in this case. And this is for 2 main reasons. The first reason for why the probability of the risk occurring in this case was low is because the threatening situation at Summerfell was so exceptional and unprecedented as to place it beyond the ordinary course of a security guard's employment. It was qualitatively different to situations that Ms. Bannister had previously encountered, and this was due to the fact that at the incident at Summerfell, there was a crowd of 250 people, as we know from paragraph 14 of the judgment. We know also from paragraphs 16 and 17 of the judgment that there was an extremely violent brawl involving an uncontrolled third party who used a weapon which resulted in the stabbing and death of Mr. Starr. We submit that these features of the incident at Summerfell are enough to render the situation an anomaly that falls outside the ambit of the ordinary course of Ms. Bannister's employment.
Well, didn't Ms. Bannister's supervisor tell her that it was part of the job? So isn't his explanation that it is something that they expect then?
Your Honour, we submit that her supervisor's comments that these incidents were part of the job should be construed as just an offhand comment made in the context of office gossip, and that this court shouldn't place that much weight on those comments and should instead examine the actual situation that occurred at Summerfell and look at how different it was to the kind of duties that she was ordinarily expected to perform. This takes me to the second reason for why the probability of the risk in this case was low, and it's because the nature of Ms. Bannister's duties as a security guard did not entail a high risk of psychiatric harm. Contrary to our learned friends, we submit that Ms. Bannister's duties are disanalogous to those of police officers and first responders, and that is because we know from paragraph 10 of the judgment that her duties largely involved guarding properties, monitoring radio communications, and attending call-outs. We accept that at most her duties involved apprehending intruders. However, However, we emphasise that this only occurred 3 times over the period of 2.5 years, as we know from paragraph 11 of the judgment. Your Honours, this goes to show that the likelihood or the probability of apprehending intruders was already quite low. And so it follows from that then that the probability of encountering a violent brawl at a street party with over 250 people is even lower.
Are these questions of fact that you want us to re-decide ourselves, or do you want us are you asking us to argue that to put that the trial judge was unable to come to the conclusion that the judge came to?
Yes, Your Honour, in the sense that the facts remain the same, but we ask the court to come to a different conclusion on whether the risk was the probability of the risk, and we say that it was low, and for that reason, it's an insignificant risk, which would not satisfy the second element required.
So you're asking us to decide that the risk of a security guard coming across a situation of violence is an insignificant risk, a sufficiently insignificant risk that we don't need to worry about it.
Yes, Your Honour, to the extent that the precautions taken by Safe State were enough, and that they didn't have to take the precautions alleged by our learned friends.
Okay. So if we decide that it's a sufficiently significant risk that the employer needed to take some precautions, or should take some precautions, the question then is whether or not they took reasonable precautions in the circumstances.
Yes, Your
And
Honour.
how much would training cost, do you think? And is training and counselling after a traumatic event unusual these days?
Your Honour, we submit that that wasn't a reasonable precaution for Safe State to take, and this is where I turn to the third element of breach, which is whether a reasonable person would have taken those precautions.
How expensive would it be to provide counselling after a traumatic event where somebody had died in the arms of one of your client's employees?
Your Honour, we submit that the cost of doing that would be quite high for a small business, and that even if it wasn't high, it's still unreasonable to take that precaution given the low probability of this kind of risk occurring, and also given the fact that the efficacy of taking the precaution of providing Ms. Bannister with post-incident support and counselling would have been equivocal at best, and this is because we know from Dr. Mormont's report at paragraph 25, 2 and 3 of the judgment that even if Ms. Bannister had been provided with timely counselling, this would have only been useful in some circumstances for some people, and that it wouldn't necessarily lead to a reduction in her symptoms at all.
So you're arguing that issue does not only go to the issue of causation and whether she would have suffered harm anyway, but as to whether or not the precaution was reasonable?
Yes, Your Honour, because if Safe State is expected to take a precaution that may or may not have been effective, then there are many precautions out there that may or may not be effective that they would also be expected to take.
I see.
If your argument is that this risk is relatively low without necessarily deciding that it's insignificant, does that not mean that the cost of providing this care would also be low because it would occur in a very small number of cases?
And Your Honour, we submit that the inquiry for this, the approach this court should take to the issue of breach is prospective in the sense that, as Justice Callanan put it in the case in the 2007 High Court decision, RTA and Dedera, it's always possible after the event with the benefit of hindsight to identify some further step that could have been taken to avoid that risk of injury, but that the inquiry always has to be prospective, and given the low probability of this kind of risk occurring, if Your Honour accepts that, then it would be unreasonable to expect Safe State to take precautions that may not have been effective, even though they may have been effective theoretically in this case for this plaintiff. Further to that, Your Honour, we submit that it wasn't reasonable for Safe State to take those precautions, particularly in relation to providing Ms. Bannister with post-incident support, because they didn't have sufficient reason to suspect that she was suffering a psychiatric injury. And
Thank you, Ms. Lee. I think your time is now up, so I think we'll move on to the next point. Thank you very much.
Thank you, and I defer to my learned junior.
Thank you.
May it please the court.
Mr. Naylor.
I will be continuing the case for the respondent, and namely responding to the responding to the appeal of Ms. Bannister in relation to Justice Bolton's findings at 96E and 96F of the judgment. That is specifically regarding the issue of damage and causation on one hand and contributory negligence. Our first submission is that Justice Bolton did not err in finding on the balance of probabilities that Ms. Bannister suffered no actionable damage, as any loss of chance which she did suffer was neither significant nor valuable. Your Honours, I turn briefly to address the submissions of my learned friend in relation to the applicability of the Queensland Civil Liability Act. We would briefly note that it is doubtful that Ms. Bannister's claim for loss of chance falls within the scope of the Civil Liability Act and within the definition of harm under Section 8 of this legislation. The full court of the New South Wales Court of Appeal, in the case of Gett and Tibet, that is the New South Wales Court of Appeal decision before it was then appealed to the High Court, noted that loss of opportunity of a better outcome in a personal injury context was at best obscure and semantically inappropriate when read into to this civil liability scheme in New South Wales, which is substantially mirrored by the provisions in this state, as in Queensland. However, we submit that Your Honours are not required to make a decision as to whether loss of chance falls within the scope of the Queensland civil liability legislation, as the main point of contention between the parties is one antecedent to this, that is, whether or not loss of chance in this context constitutes actionable damage at common law. And we would submit that contrary to the submissions of my learned friend, the alleged loss of chance to alleviate Ms. Bannister's post-traumatic stress disorder is not actionable damage, since it does not have independent value. We agree broadly with the test at law outlined by my learned friend, that is, for a chance to be actionable, it must have independent value as a question of law, and must be a significant chance as a question of fact. However, we submit that Your Honours, as an intermediate court of appeal, are bound by the High Court's decision in Tibet and Gett, and it would be an inappropriately narrow reading of that judgment to limit its application to cases of medical negligence. And were I to take Your Honours to a extract from, again, the New South Wales Court of Appeal decision, which was then upheld by the High Court, the full Court of New South Wales Court of Appeal in Gett and Tibet, at paragraph 381, stated it is for the High Court, and only the High Court, to reformulate the law of torts to permit recovery for physical injury not shown to be caused or contributed to by a negligent party, but which negligence has deprived the victim of the possibility, but not the probability, of a better outcome.
And is this court bound by the New South Wales Court of Appeal?
No, Your Honour, but 5 of the 6 justices in Tibet and Gett, that is in the High Court decision, affirmed the decision of the New South Wales Court of Appeal, and Justice Gummo, paragraph 27, explicitly approved the reluctance of the New South Wales Court of Appeal to make this radical step in changing the nature of damage at common law. And therefore we submit there is no scope for this appellate court to allow Ms. Bannister's chance as actionable damage.
Mr. Naylor, even if you were correct on this point, I'm still troubled by paragraph 25 of the judge's judgment that there's evidence, which seems to me to be unchallenged, that Dr. Mormont had diagnosed Ms. Bannister as suffering from post-traumatic stress disorder.
Yes, Your Honour. It is not disputed between the parties that Ms. Bannister does, in fact, suffer from post-traumatic stress disorder. However, the question is whether or not the actions of our client's safe state security contributed to or caused a loss of chance for her to alleviate this condition. And so therefore the state, in fact, that she does have this condition is not sufficient or does not show any wrong on behalf of our client. And we submit further that the treatment of Tibet and Gett by the High Court in later decisions, we note specifically the unanimous decision of the High Court in 2016 in Robinson Helicopter and McDermott showed or affirmed to Your Honours that you are bound by the High Court's ratio in Tibet and Gett.
And what did they say in Robinson Helicopter?
In Robinson Helicopter, the unanimous High Court said at paragraph 86 that first, at a level of principle, this court has set its face against recovery of the loss of chance in the law of negligence relating to personal injury. the context of medical negligence on one hand and the employer-employee context in the present case, does not provide Your Honours with sufficient scope to allow a finding that loss of chance constitutes actionable damage.
Thank you, Mr. Naylor. We might move on to your last point.
Yes, Your Honour. Moving on to the issue of contributory negligence, it is our submission that taken together, Ms Bannister's decision to leave her car in the circumstances, her failure to call for assistance, and a decision to remain in a position of risk amount to contributory negligence as they fell short of the standard of care of a reasonable person in this scenario. And this is by reference to Section 23 of the Civil Liability Act in Queensland, which directs Your Honour's attention in evaluating the reasonableness of Ms Bannister's conduct to Section 9 of the Civil Liability Act, that is, the same provisions which govern the breach.
Ms Bannister was put in the agony of the moment, wasn't she? That her reaction was one that she took when she was put in a position not of her own choosing. She had duties to carry out and she chose to step in. Isn't she in a position where we have to give her some latitude, that she might have made a slight error of judgment, but not from a position of her own choosing?
Your Honour, we submit that Ms Bannister was not in the agony of the moment in any material sense, given that when she arrived at the property in paragraph 14 of the facts, she made a decision to exit the car and placed herself thereby in this situation. And therefore any temporal pressure or any agony of the moment, as Your Honour put it, to which she was subject was of her own doing.
So you're arguing that she has to bear entirely the risk of this sort of thing on herself, and that her employees have no responsibility towards her?
That is not the extent of our submission, Your Honour, only that her actions in exiting the car, failing to call for assistance and remaining in this position did amount to contributory negligence.
So then are you not submitting that the 100% apportionment should be upheld, or is that your, in fact, submission?
That is our submission, Your Honour. However, we submit that for Your Honours to even be considering the issue of contributory negligence, you must be satisfied that Safe State has breached the duty of care and caused Ms Bannister damage. And so therefore, a finding of contributory negligence, or even a finding of 100% apportionment, is not mutually exclusive with a breach of duty by Safe State.
And have you been able to, in your researches, been able to find any case in which a court has made a 100% reduction for contributory negligence since this legislation introduced the capacity of the court to do so in 2003? 16 years this piece of legislation has been enforced. Have you found one example of where a court has actually applied it?
Regrettably, Your Honour, I have not, or we have not in our searches. However, we submit that given that the decision of apportionment is discretionary, it is incumbent upon the appellant to show that the apportionment of the trial judge was unreasonable or unjust, as per the decision of House and King upheld in this court in Queensland and Kelly in 2015. Yes, Your Honour.
Given that you have accepted that there may have been a breach of duty on the part of the employer, on what basis are we to, and that may have been causative of the injury, on what basis are we to make a 100% apportionment? What principles are to apply?
Your Honour, to make an apportionment of 100%, requires essentially a balance between the relative departures of the two parties from the standard of care of a reasonable person, and also the causal potency of this in causing harm, and that comes from the High Court in Pot Reversal. And we submit that while Safe State, if Your Honours do find that Safe State has breached the duty of care to Ms Bannister, that Ms Bannister's actions on the night of the 20th to 21st of May were much more proximately causative of her harm, as for example, had she not exited the car or had she called for assistance, she would not have been in this position and would not have suffered post-traumatic stress disorder. And given the proximate causative potency of her actions, this justifies a 100% apportionment of contributory negligence.
Thank you, Mr. Naylor.
May I please the court?
Well, in a real moot, we would now retire and then go away and we would work out who we thought was the better advocate. We might make an attempt at giving a judgment on the facts, and it's probably not too difficult to see which way we might go, because the facts sometimes the facts that are given make it a very hard case for one side to argue. They're asked to argue something which really is fairly insupportable on any sort of moral or just basis. But that doesn't mean that they can't argue it and they don't have a duty to argue it. So some issues are much easier to argue than others, and we might go away and make a judgment about what we think, but more likely we would go away and we'd have to, as you can imagine, a very hard decision of deciding which mooters actually win the competition. Now, as you can hear today, that would be an extremely difficult decision for the judges to make, because as you could hear, all our mooters were able to put their case very well, very logically, their submissions were clear, and most importantly, they were all very good at answering questions. We were more polite than some judges. You might have thought we were rather rude, interrupting them constantly and interrupting their flow, but we actually are quite a polite lot, I think, compared with some. But that's one of the things they have to get used to. Somebody breaking in their train of thought and saying, oh, but what about this, what about that? And often the judge is being a devil's advocate, saying, well, have you thought about this? Because they want the advocates to have addressed a point so that nobody can argue later that that point wasn't thought of, and to dismiss, and so then they can have a fair chance to argue about a point which might turn up in the judgment. So as you can see, it's a real challenge for our mooters. It's a difficult job that they have, but as you could see, all of these mooters did it very, very well, and I'm sure we'll see them in our international competitions before their legal studies are out. So thank you very much to the mooters this morning. Anything else you'd like to add, Sharon? No? No? And thank you very much all for coming and watching their performance. As it is a performance, as you can see. Thank you.